Hello friends, Mandar here. I am back with another video. Today we'll talk about some of the updates that USCIS has given through its Twitter account and also on its website. There are some important things like flexibilities that were announced in March of 2020 at the beginning of during the pandemic are now about to end. There is also a funny tip that USCIS is saying that they are committed to use up all the visa numbers, and some updates that they have given about being able to search for a job by being on B1, B2 and the 60 days grace period clarification. There are some rumors around this topic that I wanted to clear. So there are a lot of important topics in this video. Watch this video until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration and lifestyle related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. And for your specific immigration needs, before you take any action, you should hire a competent immigration lawyer. Now check out the links in the description that you might find something interesting. And while you are down there, please hit the like button. That will greatly help the channel. And if you want to get in touch with me, do contact me on my Patreon or Calendly. On Calendly, you can set up 30 minutes with me for my non-legal advice or opinion. Now let's talk about the first topic. Now the first topic is USCIS at the beginning of the pandemic, specifically in March of 2020, they allowed some flexibilities in response to some of the things, typically in terms of response to the letters that they require to be submitted within a certain duration of time. Now these flexibilities are ending as of this month, end of March, and USCIS has clearly noted them in a tweet and also on their website. So let's take a look at them. Now the first one is USCIS announces end of COVID related flexibilities. You want to pay a very close attention to this because this can get back to you if not followed correctly. The impact of not doing this in time is that you may be faced with an NOID, which is notice of intent to deny your application, and which is not what you want to get. If it is not actually a denial, but it can be a beginning of your denial process. So this was published on March 23rd, 2023. USCIS today announced that certain flexibilities it first announced in March of 2020 to address COVID pandemic will end on March 23rd, 2023, which is already ended. So basically they announced that these flexibilities are ending right away on the day that they published this. The extensions of these flexibilities announced on January 24th would be the last. You must respond to any notices or requests from USCIS dated after March 23rd by the deadline listed in the notice or request. These include request for evidence, which is RFEs, continuation of request evidence, which is N14, notice of intent to deny, notice of intent to revoke, notice of intent to rescind, notice of intent to terminate regional centers, notice of intent to withdraw temporary protection status, motion to reopen, N400 pursuant, receipt of derogatory information after grant. So these are basically what it boils down to, and this has a common theme. Any notice that you get from a USCIS for your action to be taken, they always give a deadline to it. During the pandemic, they had relaxed these deadlines from say 30 days to 90 days or 30 days to 60 days or in some cases up to 180 days. But now starting right away, which is March 23rd, any notice you get after March 23rd, you have to respond to that notice with the required documentation. If it is an RFE, respond back with the documentation that they have asked within the timeline specified in the letter. If it's within 30 days, you have to respond within 30 days. If it's within 60 days, you have to respond within 60 days. There is no grace or there is no extension that was put in place during the pandemic time. So this is absolutely critical. Don't be complacent. If you get a letter from USCIS regarding taking some action within some duration, you have to treat it very seriously and take an action within that date, or else you will face NOID, which is notice of intent to deny, or even deny your application. So that is the first point I wanted to cover. Now the second point is I just wanted to kind of mention it because they have been doing this since last couple of months, that USCIS is committed to using as many available employment based visas as possible in 2023. To better assist interested applicants, we have created a list of frequently asked questions, and these are questions and answers. So here is how it looks in terms of question and answers, and you can take a look at this. It has a lot of interesting information. They talk about what were the number of EB visa numbers that were available last year, and it was almost 281,000. And you know, because of the pandemic spillovers from FB category, we got a lot of visa numbers in the last 2 years, 2021 and 2022. But this is the new year, 2023, and this year we only got about 57,000 spillover in October from the last year from family based category. So the actual number today in this current fiscal year is only 197,000 visa numbers. Now if you look at it, last year they processed even more than this entire number for this year. So what they are saying is they are planning, or they are committed to issue all these green cards or use up all these EB visa numbers. So basically 197,000 visa numbers this year, which is what is expected from them. So I don't know why they saw a need to come out and say it out, that they are going to use it. I have no doubt that they will use it up. I will be very surprised if they had processed more than 225,000 EB numbers last year. Why couldn't they process 197,000 visa numbers this year? So we'll see. I would be very surprised if there are any wasted visas in EB category this year, because the number is significantly lower than last 2 years. And these Q&As will go through a lot of different possibilities. Some people ask me what happened to those spillover numbers of 60,000, which is actually 57,000. Well, those numbers were already taken into account when they calculated the filing date chart and the final action date chart for the entire year. Basically filing date chart for the entire year. So those numbers were already counted towards the pending applications. Now one would say, how would these numbers, 57,000 numbers, would have been used by the pending applications, because all of those applications are retrogressed. Not all of them have retrogressed, mind you. Some people have retrogressed, because the dates proceeded up until December of 2014 for EB2, and now it's back to 2011. But not everybody retrogressed. Some people whose dates are still in 2010 and 2011 are not retrogressed. They are still pending, and they may be the ones who have used up all these visa numbers, or these visa numbers are still available to be used by the throughout the entire year. So I think there are so many applicants before even these dates. So before June of 2012 for EB3 and before January of 2011 for EB2. These are enough applicants to use up all these 197,000 visa numbers. That's the way I read it. So let me know what your thought is on this pending visa numbers being used up by all of these 197,000 visa numbers. Whether or not you agree with my assessment or not, put down in the comment section below what you think about it. Next one I wanted to cover that USCIS is also said is, many people have asked if they can look for a job while in B1 or B2 status. The answer is yes. Searching for employment and interviewing for a position are permissible in B1 and B2 activities. So basically it all stems from the fact that if you are on a H1B visa and if you get laid off, you only have 60 days grace period to find another job and file for an H1B transfer. So that is what you should do within that 60 days. Whether you are able to do it or not, that's a separate story. But if you cannot find a job and if you cannot file for your transfer within 60 days, then you need to leave the country after 60 days. So that is very clear, and you should not violate this rule. But if you don't have that sponsoring H1B, then the alternative is you can go on B1 B2 visa. Now B1 B2 visa would be change of status visa, so you'll need to apply for that and it will need to be approved, because if it doesn't get approved, you will still have to leave the country, and that's what they say in the following tweets. So say for instance you are able to transfer from H1B to B1 B2. In that case, what USCIS is saying that you can continue to look for a job and you can continue to interview for the jobs while being on B1 B2 visa. Now this was not true, or this was not always the case. They never said it out clearly. In the past, things were different. If you went into the consulate abroad and if you apply for a B1, B2 with an intention to work in the United States, there was a chance that your visa would have been denied. But now what USCIS is saying, that if you are in the US, you are facing this 60-day grace period after you lose your job on H1B. And if you change to B1, B2, if you are able to do that, you can still apply for or look for a job, and you can interview, and you can apply and you can do the interviews. It's just that you cannot start working on B1, B2. Now, as I mentioned, there are other clarifications that they have made. Alternatively, if the change of status request is denied, or the petition for the new employment requested consular or port of entry notification, the individual must depart the US and be admitted in an employment authorized classification before beginning the new employment, just like what I said a few minutes back. Now, they also have mentioned that we have seen questions on options available for non-immigrant workers following a termination of employment, including will a pending I-539 change of status application to B1, B2 be prioritized if a new employer files an I-129 petition with the premium processing service request? If USCIS approves the I-129, including any requested change of status, then you generally will obtain requested non-immigrant status on I-129 petition, not the 539, and may begin working. So they are saying as long as you get the receipt notice, you can start working. You generally wouldn't need to deport the US to obtain non-immigrant status. So they are saying if you apply for I-129 in premium and it gets approved, you can start working and you don't need to self-deport. So these are some of the questions that they have answered on this page already. So options for non-immigrants following a termination of employment. If you haven't read through this page, I highly recommend read through it because it clarifies a lot of doubts. Now, the final point I want to cover in this video is about the 60 days grace period. Now, there is a rumor mill going around that this 60 days grace period after your job is terminated on H1B has been extended to 180 days. I have scoured through the USCIS website. I haven't found any evidence of this. I don't know where this rumor mill has started, but there is no extension of grace period from 60 days to 180 days. I think in one of the suggestions from Immigration Advisory Board, they may have suggested this to be done to increase the grace period from 60 days to 180 days. But it is not a law. It has not been signed by the president, and that is not the case. So the grace period remains at 60 days as we speak. So again, the clarification on the grace period is if you are on an H1B, and if you lose your job, basically your grace period, it starts the next day of the last day of your payroll on your company. So if you are employed with the company say until 31st of March, your grace period will start on 1st of April. So count 60 days from that period, and that will be your grace period to find another H1B employer who is willing to transfer your employment, is willing to transfer your H1B, and your petition for a transfer has to be filed before the grace period in order for you to be able to stay in the United States. So that is the clarification. And another thing people keep asking, does your severance allowance, so say for instance your last payroll date on the company's payroll was March 31st, but they have allowed you, or they have given you a severance or a pay for the next 3 months or a 6 months period, which some generous companies apparently do. It doesn't mean that you are on the payroll during that period. Your last payroll is the last day of your work in that company. So that's when you used to start counting your 60 days grace period. The severance and the additional pay that they give as part of the severance, that doesn't count as part of the grace period. It is very important to note. So I know for sure that some of you are interested in stock trading, day trading, buying cryptocurrencies. I want to present you VBull. VBull is a trading platform. It allows you to buy stocks, it allows you to buy options, do options trading, and also it allows you to buy cryptocurrency. It can be done on the computer or on the mobile app. Now if you use my link, which is on the screen and also in the description, you will get some free stocks. Webull has announced that it will give 12 free stocks if you use my link, and those free stocks will be valued up to maximum of $30,600. So when you open an account using my link, you will get 2 free fractional share stocks. That value could be anywhere between $3 to $300. If you deposit at least 1 penny, you will get 4 to 10 free additional stocks valued from $7 to $3,000. So that's 12 stocks from Webull free for you if you use my link, and enjoy your free stocks. So really that's all I wanted to cover in this video. If I haven't covered any important topics, do let me know in the comment section below. If you need my personal opinion on your case, do contact me on my Calendly or Patreon. Hopefully you like the content of this video, and I'll see you in the next one.